Thank you for the kind words. Good afternoon. I know it's a very difficult session to handle after lunch. At the outset, let me thank Kita and Kim and Chang for giving us this platform to share views and exchange ideas with the wonderful audience here. You must have heard all my learned colleagues since morning. What exactly these things bring on the table for us is basically the opportunities which are being created under the various agreements that have been executed by the contracting parties. And in particular, I'm going to talk about India. India with a population of 1.3 billion, just next to China. The Comprehensive Economic Partnership Agreement, which is in the nascent stage and has been signed sometime in January 2010, creates a tremendous opportunity and has huge potentials. An effort to capitalize on it should be made by the interested parties of the respective jurisdictions. And before you take that step, you need to know the system. The focus of the seminar is to basically to familiarize with the audience here with the prevalent systems in the respective jurisdictions. I'm going to talk about the Indian jurisdiction in particular. And I've heard my colleagues since morning, the rules across jurisdiction, I confess the rule across jurisdiction are 80% same with the 80% same with a minor variation. To start with the answering to the question which my colleague had asked just before the lunch break. It was a question that can an exporter from a third country can directly ship from Korea to India? Yes, in that event. There's third-party invoicing, it can be done. So with a minor modification, the rules are uniform across jurisdiction. Without much ado, I'll just go back to my presentation now. This is basically the framework of my presentation. First part of my presentation deals with the brief introduction to the SEPA, which India and Korea is a contracting party, then the rules of origin under SEPA for the Korean products. This is the heart of this agreement. This is the heart. Then the clear assessment and collection of duty, then the legal framework of dispute resolutions. These are all fallout, but the rule and origin is the heart of such kind of agreement. SEPA is much more than your preferential treatment rights. It also covers the investments. So it's the approach and the ambit is much wider. The agreement between the two contracting parties was signed in August 2009, and once an agreement is signed between the two sovereign countries, it has to be ratified by the parliament. That's the law. It was ratified in November 2009, and finally it came into effect on 1st of January 2010. What was the object and intent of that agreement? The object and intent of the agreement is twofold. One is reduction, one is elimination. So in stages, the duty is to be reduced or eliminated. Each party had its respective obligation. Like for Korea, it was 93%. For India, it was 85%. And the ultimate result of this is the boost in the trade, which you can yourself see it was 3.3 billion, which is being targeted. Though this particular agreement is in the nascent stage, and I do admit, India with a GDP of close to 7% and an emerging economy, there are teething problems. You will face problems with our custom authorities because they are overburdened. The trade today is on a rise, so they may not be in a position to really in toto comply with the letter and the spirit of the terms and conditions of the agreement. But I think, yes, in due course, they will streamline the procedure, and I don't think you will have an opportunity or anybody would have an opportunity to crib about it. Pursuant to the agreement, specific rules of origin have been framed for various products. Now, the products have been categorized, which is we call it as staging categories, which applies to reduction or elimination of custom duty by each party, that is each contracting parties, which are as under. Basically, the first three, E0, E5, and E8, it has a schedule also annexed to it, which lists out the various items. The first three item is basically elimination. The duty would be eliminated. Like, for example, in E0, the day agreement comes into operation, the duty would be 0. Like E5 and E8, the duties would be reduced annually. Like, for example, E5 in 5 equal installment, E8 is a similar 5 equal installment. Red and sin is basically a reduction in duty. Like, from 10%, the duty would come down to 5% in a systematic way. So the last two, fourth and fifth is reduction. First three is elimination. XC is basically the tariff, preferential treatment does not apply. Any goods originating from Korea will not be entitled to that treatment. It has a list which has been annexed along with the rules, which you will see later. This is basically a bit of a municipal legislation or the national legislation, any agreement which is signed between the two two parties cannot become a law unless and until it has been incorporated into the municipal law, except for fundamental rights, which you can read into it. But it has to be so. Accordingly, pursuant to the SEPA, which was in January 2010, custom tariff, determination of origin of goods under the preferential trade agreement between the Government of India and Republic of Korea, Rules 2009, were implemented or formed, which was notified by the Government of India via notification number so and so, and has been enforced since 2010. So this is the rule. This is the rule. Basically, the custom tariff rules 2009 governs this. So we need to be clear that when we are, if you are exporting from here, this is the rule under which you will be governed, which sets down the various rules. It also has sub-rules attached to it. Now, some relevant rules, I think it would be important for me to take you through. It would give you an insight also into it, as this is basically a practical lesson, and I would love to go through this. Now, Rule 3. Rule 3 of the said rules is basically deals with when the good is deemed to have originated. Consigned as per Rule 14, which we'll see later, goods wholly obtained or produced in Korea. What does it mean? Goods wholly obtained or produced in Korea means there are two roles. One is the exporter, one is the manufacturer. If you exporter procures it from the manufacturer, then it is obtained. And if it's the manufacturer directly selling, it's produced in Korea. For example, you can have a subsidiary in third country like Thailand, and it manufactured here in Korea. So your subsidiary in Thailand can obtain and ship directly from Korea to India. So this is the concept behind this. Goods not wholly obtained or produced but eligible under Rule 5, which we'll see next. These goods, aforesaid goods like 1 and 2 are basically 3 are eligible for preferential treatment. Rule 4, goods wholly obtained or produced. There are 10 categories of goods. We can go through the list as in when we have time. Under this rule, list provided in the rule itself. Rule 5, good, which we refer to, just we go back for here, which we read, goods not wholly obtained or produced but eligible under Rule 5. What is Rule 5 basically? Goods not wholly obtained or produced deemed to be considered as originating, satisfy the criteria under product-specific rules, or if not covered by the above, the regional value content is not what we call the value addition. Suppose if you have some product is coming from a different country, jurisdiction, but if there is a value addition of 35% is a must, which has been specified under the annexures, there has to be a value addition. It would be eligible for the treatment. Goods have undergone a change in tariff classification in subheading at the so-and-so level from, because you obtain a raw material and you do a further operation on it. Definitely there is a new product which comes into existence, it changes the nature. In that event also, you are entitled to the preferential treatment. Final processing of manufacturing is, suppose if you procure a material, but the final processing is done here, where if it is more than 35%, it is supposed to be goods manufactured in or performed in Korea. Residual processing, not deemed to be original. Okay, last is not that important for us right now. Rule 7, non-qualifying operation. Basically, it provides a list which is not entitled to direct consignment. Goods transported directly between India and Korea. For goods in transit through third countries, be considered consigned directly. For example, as long as it does not enter into the commerce of that particular country where it is through which is transit, it is considered to be entitled for the treatment. It's only as long it is within the authority or within the ambit of the custom authority there and does not enter the commerce of the third country, you are entitled. It can be considered as a direct consignment. Goods must not have entered the trade or consumption there. Good must not have undergone any operation there other than unloading or reloading, which my learned friends have said this morning, for maintaining conditions, so and so. Goods must have remained under the control of the custom authority in the country of transit. So the three important things: it should be in the control of the custom authority in the country of transit. It should not have undergone any operation except for loading, unloading of operation, and should not enter that country for consumption or enter into the commerce of that country. If these three conditions are satisfied, it is considered as to be a direct consignment. Now, this is the certificate of origin. This is what I call it to be the heart of this agreement. Goods eligible for preferential treatment is to be supported. Yes, this has to be supported by a certificate of origin. Now, how do you get that certificate of origin? Who's authorized? Both the subcontracting parties have nominated the respective department of the officers, each jurisdiction, to issue this certificate. Like certificate in Korea will be issued by the designated authority designated by the government of Korea, that is Korea Customs Service, Korea Chamber of Commerce and Industry, and any agency authorized by the government, which is provided in Annexure 4 to the rules. Certificate, secondly, why I said in the beginning that you need to follow the rules religiously. If you don't follow the rules religiously, I think you will not be entitled to the benefits under the agreement. And the certificate is to be as per the format. In India, they are very particular about the formats and the procedure. So certificate is to be as per the format specified in Annexure 5 to the rules. Detailed operational certificate procedure also as per the Annexure NEC. Now, what is the procedure there for regarding claiming of the certificate of origin? Producer or exporter claiming preferential treatment to apply in writing to the issuing authority for pre-export verification. If I am exporting from India to Korea, I'll apply to the respective or the concerned authority for pre-export verification. Then the issuing authority would conduct a verification, pre-verification at my site, and result of such verification shall be accepted subject to review or supporting. If there's any discrepancy, they would call upon the respective parties to rectify the same. And then after the pre-export verification, may not apply for goods whose origin or virtue of nature cannot be easily verified. There are certain products whose nature or origin cannot be verified. They issue a certificate to the exporter for claiming the preferential treatment under the agreement. Where the exporter is not the producer, what happens? When the exporter is not the producer, application to be made on the basis of declaration by the producer that the goods qualify as originating goods and may include result of pre-export procedure. Suppose I'm a producer, I don't directly export to the country with whom I have an agreement. So any trader can apply on my behalf, supported by the pre-export verification evidence, and ask for that right under the said agreement. What are the duties basically now of the issuing authority when they carry out the pre-export verification? While carrying out the pre-verification, the authority has to really carry out a proper examination upon his application, that it has been duly signed by the exporter, the origin of the good is in conformity with the rules, other statements of so-and-so has corresponds to the evidence that has been supplied, export of multiple items declared on a single, it is in India allowed. As for the EU and other countries, I think you have to do it for each product. You have to get a different COO, but in India, on a single COO, you can have number of items. Each item qualifies as originating goods under the rules. Now, this is also very important, very, very important, because CO has to comprise of one original and 3 copies, printed format or any other medium that is prescribed, completed in English, which has to be in conformity with the specimen of the Annexure 5 of the rules, issuing authority to retain duplicate copy with original and 2 copies to the exporter, exporter to forward the original and copies to the importer, no eraser or superimposition, because I had an opportunity to go through this, the last one from Sri Lanka, where they had used the eraser and it was rejected. No eraser or superimposition on the CO and unused spaces to be crossed. This is very important. That's how I say, once you want to really avail the benefit under the agreement, you have to religiously follow the rules. If you don't follow it, basically you have waived off your right to claim the same. Then CO that has to be issued at the time of the export or within 7 days, working days from the date of the shipment, wherever the goods to be exported, and can be considered as originating. If it cannot be issued per above exceptional circumstances, it has to be then in a remark column you have to put in that it has been issued retrospectively. So wherever it is retrospectively, it is allowed, but it is advisable not to use this options, because once you have got the final duty done, then the authority are generally reluctant to really review this. So it's important that if you don't have COO and your goods have landed in a different the jurisdiction of the subcontracting party, please only get the provisional assessment done. Never get the final assessment of the duty done, because for you to claim the refund or claim the right would be very difficult. And I'll later in my presentation, I'll tell you there are disputes which have gone to the Supreme Court also on the said issue, because they got the final assessment done and the certificate was issued retrospectively. The authorities have rejected it. Though the law permits it, though the rules permit it, but the authorities, there is like an inherent contradiction between the functioning and what is the law is. So it has to be set at naught by, at some point of time, by some competent court of law, which will be done. Issue cannot be, it cannot be issued later than 1 year from the date of shipment. In case of loss or destruction or theft, certified true copy is good enough as a proof. In that event, it has to bear the mark, it has to be certified true copy in remarks box, and to bear the date of the original COO. Validity of any certificate is 12 months to claim the preferential treatment, and it has to be made within the set period. Any CO certificate submitted after 12 months may be accepted in accordance with the procedure of the member states. You can always have a variation. There are discretion with the authorities. Even if you submit it after 12 months, it is up to the authority to submit or reject. You know, there are basically minor discrepancies does not lead to invalidation. Yes, but we need to be careful because it's basically the discretion which is being exercised by the authority. So if we follow the rules, I think we should avoid even the minor discrepancies in the certificate. Origin verification. India may, generally does, India may at random or when it has reasonable doubts about the product, request the authority in the contracting party for a retroactive check in accordance with the rules provided therein. Request has to be submitted with the certificate and reasons, and the issuing authority shall, that's the law, shall respond and reply within 3 months. But I have not come across where it has been done within the 3 months. As in the lunch table, I was talking to Mr. Kim. He said he has sent a request and it has not been responded for last 4 months. So these are the nascent and the teething problems that we are facing, and I think, and it would be streamlined in due course. Custom authority of importing state may suspend provision of preferential treatment while awaiting. Yes, what happens is, till the results are not made available, that you cannot get a treatment. After the result is received, the authority of importing country will decide. Process has to be completed within the 6 months, though this is the timeline, but I have never come across whether within 6 months it has been done. Because importing country takes much more than the stipulated time to respond or to even send a request, then the contracting party also takes much more than time to respond back. So it is advisable that instead of sending your goods to the ports where it is being manually handled, it's advisable that you send it to the ports where it is computerized. So it's easier than to save on these timelines. Importer may be requested for information or documents relating to our origin. That's the obligation on the importer, where I think the exporter really needs to cooperate and support. If the authority of the importing country is not satisfied with the retroactive check, may under exceptional circumstances carry out verification in the exporting country by written request for information or documents, verification visit to the premises of the producer and exporter. This is a difficult area. Basically, sometimes it has been refused by the exporter because they say, we can't give you an access to our confidential document, which results in denial of the right under the agreement. So here, I think the authority of the tourist contracting parties, country should come into play and really negotiate between the parties so that the exporter is not deprived of the benefits, or the importer is not deprived of the benefits under the agreements. Written request to the producer or the exporter shall indicate time or frame of response within a minimum of 30 days from the receipt of any further time as may be agreed between the parties, so and so. If after the receipt of response to the written request, additional information is needed, such request may be made. If you need more time, because your plant may be somewhere else, if you need more time, you can always request the authority for extension of time. If the producer or the exporter fails to respond back in time, preferential treatment may be denied. Yes, if after the stipulated time, you don't say, if the response is not sent within the stipulated time as per the request, you may be denied the right under the Act. In case of a physical verification to be carried out, then importing party to deliver written notification of its intention to conduct verification. Suppose if a importing party wants to carry out verification, he has to do it in writing, which is very important. Issuing authority, custom authority of the state party where the verification is to be carried out, so and so. Written notification to consist of the following. These are very important. So these are the basic ingredients. What a written notification really need to have in it. So it's the name of the custom authority issuing the notification, name of the producer and exporter to be verified, dates, what is the ambit of the verification, and the name and designation of the officials who would be conducting the verification. Then you need to have the consent in writing from the exporter that he is willing to submit to the verification in order to get the benefit. If the consent is not given within the time stipulated, then the preferential treatment may be denied to that party. Also, the authority in Korea has a discretion to postpone the verification, or these are the basic formalities which are there attached to the verification, that if exporter wants to have a third party to be present there as an observer, he can request for an observer. Post verification, then the importing country will provide the whole report, verification report as to the origin of the goods which were verified. Then the producer may provide its comment within 30 days from the receipt of the written determination about the origin. This process has to be completed within a 6 months, right from the first day of verification, the request. But it's generally, though the law is 6 months, generally it takes more than 6 months in my experience. Because what happens is sometimes they don't get permission to travel abroad also. Sometimes somebody goes sick, somebody, the producer is not willing to submit, sometimes they agree later on, sometimes the authority says, I'm postponing it for 2 months. So generally the law is 6 months, but it's never completed in 6 months. This is a format of the certificate of origin and instruction for companies. So Annexure A. Annexure A is basically the format of certificate of origin which all of you have in your paper book. And it carefully needs to be filled in. I don't need to refer to it. If you have any issues on that, you can always refer to Kim and Chang. They'll help you in completing it. Then some of the case studies where the rights have been denied. And more so, this is because of the anti-dumping, which has been basically duties being levied on various products coming from various countries. What is happening is, under the garb of PTA, the goods which are being manufactured in different jurisdiction is being shipped through a third country, only putting a label of being manufactured in XYZ country. One of the case study on this is like Surya Light versus so-and-so. This was SESTET. SESTET is basically appellate tribunal in India, which exclusively deals with the custom and excise matters. In this product, the assessee claimed exemption under the India-Sri Lanka FTA as goods originating in Sri Lanka. Custom authorities investigated and held the origin of the good was China. Original invoice was fabricated as shown origin was Sri Lanka. Then the goods were confiscated, and redemption, and the duty, rejected the CO and levied redemption fine. And also a penalty was imposed. Then the aggrieved party moved to the SESTET, which, SESTET really basically upheld the finding of the commissioner, who is basically the first point in charge. Then it went to the Supreme Court, and the Supreme Court also finally upheld the findings of the SESTET, thereby depriving the party of the preferential rights as claimed under the agreement. Now, on arrival of the goods, suppose between the two contracting parties that the good arrives, lands in the the importing country, basically the Customs Act 1962 of India governs the whole procedure. I don't want to get into the procedure. It's available also. Anybody can read it. It's not a rocket science. All of you are familiar with this because you are into this trade. So all of you are familiar with this. This is a general practice. It doesn't need a legal interpretation to this. It's not because of the color, because in case of Indian subsidiary of Korean producer exporter as importer, the type of BOE, that is bill of entry, has to differ. If it is for your home consumption, your bill of entry has to be of white color. If it's for warehousing, if you have a subsidiary in India and if goods are going to a warehouse for further transshipment, it has to be yellow color or whatever it is. So the color is color coded, basically. What we call is a color coded, and it has an importance, not in terms of only color, but its size also. So you need to be careful on this aspect. What are the essential documents to be submitted? Which is a must-do list, which is invoice, packaging list, bill of lading or delivery order, duly filled in GAT declaration form, duly signed importers or CHA declaration, import license, letter of credit, wherever necessary, insurance memo, certificate of origin, if preferential rate is claimed, industrial license, technical literature, test report in case of chemicals, advanced license in original, split up of values of spares, components and machinery. This is important, I'll discuss later. No commission declaration. Importance of such document is to enable checking of the goods, deciding the value and classification, which is very important, ensuring import is legally permitted. Assessment and duty clearance. Noting of the bill of entry, cross-checking of the BOA with import manifest. These are all procedural aspects, which in my view, I think needs to be complied, which I have been saying again and again religiously, so that you are not deprived of the benefit. The timelines are set out there. Once the SIP arrives, this formality has to be completed within 3 working days. If it is not removed in time, the demurrage has to be paid to the port authorities. And then the BOA may be presented with 30 days before even you can do that in advance also in 30 days. Assessment of the duty is done after BOA is filed and is done by the appraiser, which is the custom authorities. Then the appraiser has to correctly classify the goods, decide the value for purpose of duty, find out the rate of duty and applicability exemption, verified goods are not import in violation of any law because it should not fall in a negative list. Has the power to have the goods examined, same is indicated at the back of so-and-so. Valuation of the good to be provided by the importer. Valuation can be rejected, depends upon the valuation reason to be provided. But generally it is not done, except when it is like undervalued. These are also like continuation of what I said on the clearance system. These are the formalities, one that needs to go through. These are very important aspects. Then there is a second appraisement system on the basis of the documents submitted. Good may be examined thereafter. Examination done on a selective basis is done. Payment, then there's a payment and of duty and clearance. If the goods are moved to a warehouse, no duty payment is required. Bond has to be, you can move the goods to your warehouse on executing a bond. If the goods are moved for home consumption, then the duty is to be paid. There's nothing required to be said on this. This duty may be paid in cash or through a particular challan that we have in India, that is called TR6 challan, or through the provisional duty account. Duty to be paid within 5 working days after BOA is returned to the importer for payment of duty, else interest is charged payable. You can only clear the goods, that's all procedural aspect. Now this is settlement commission. This is a very important aspect, a new development which has recently taken place in India. You know, if you don't want to really litigate, suppose if you're aggrieved by any of the decision of the findings of the custom authority, if provided you meet the benchmark which has been set out in point 2, that the value is more than around close to 4,000 USD, you can directly go to the settlement commission, and the decision of the settlement commission is conclusive. It cannot be opened in any court of law, and it is binding. Any importer or exporter or any person at any stage of a case make an application containing full and true disclosure of his duty liability which has not been disclosed before the proper officer. He can go to the settlement commission, disclose the true duty liability. The settlement commission in that event may fix a date to see whether it is a fit case for hearing it or being admitted. And once it is admitted and hearing is given to the parties, the case will be disposed of, and if there is any requirement of investigation, it might do it also. Time taken to dispose is 6 months to 1 year maximum, and it's generally disposed of. I have seen it more than 3 to 4 months it has been disposed of. And this is very important. Order is conclusive. It cannot be opened in any court of law. This is basically the appellate procedure. Suppose if you are being aggrieved by any of the findings of a custom officer with regard to the valuation, which is done within a year, you can approach the Custom Excise Gold Control Appellate Tribunal, CGAT, or the High Court as the case may be, and against the findings of these courts, the appeal lies to the Supreme Court. The time before the commissioner varies is from 1 to 2 years. Then SESTAT is, I think, it's a prolonged litigation there because we have only one forum, SESTAT, which is New Delhi, and there's huge pendency of case, so it might take more than 5 to 6 years. Then there's a statute of limitation. Suppose if you are aggrieved by a decision of a custom officer, you can file an appeal before the commissioner within 60 days of the order received by you. And if you are aggrieved by the order of commissioner appeal, then you can go back to the SESTAT, which is within 3 months. But if you go to the SESTAT, there's one condition precedent that you have to deposit, pre-deposit of the duty that you are appealing against. SESTAT has a discretion to do away with, but in most of the cases, you will have to deposit 25% of the disputed amount. Then this appeal to the High Court against any order of the SESTAT, you can go to the High Court, provided you meet the classification as set out therein. The limitation, like within 180 days, is the time period which you can approach the High Court. And then finally, Supreme Court, which is the apex court in India, where the limitation is 60 days. One case with regarding to classification was basically laptop, because the importer, the HP India, requested the authority, custom authority, that the laptop falling under CTH 84.71 should be classified under the on the value to be determined by the deducting only the software, and the software was in the hard disk. The custom authority said no. They rejected the defense of the HP India. They challenged it in the SESTAT. SESTAT basically set aside, acquiesced the finding of the commissioner appeal. Then the department went in appeal to the Supreme Court, and the Supreme Court said, with the software preloaded in the laptop is classifiable as a separate entity under so-and-so at nil rate of so-and-so level. And finally held that the preloaded, this is important, preloaded operating system recorded in HDD in the laptop forms an integral part of the laptop and is to be classified under CTS so-and-so. This is why I said this, because if you remember in the beginning there was classification or change in the HS code. So once you have a raw material where the HS code is different, when you put it into a system, the HS code can be different. The exporter and the importer asked that it should be separately considered, but the authority rejected it, and which was finally the said finding was upheld by the Supreme Court. So the change in like HS code and all, you have to be very careful when you are claiming the right under the said agreement. Now these are the conclusions. Basically, rules of origin pursuant to the SEPA has been incorporated in the municipal laws of India. Import verification assessment of duty has remained similar to those in the normal cases. There's not much change in it. Clearance of goods and payment of duty has more or less remained similar to those in the normal cases. There's not much change into it. These are my observations. I may be wrong, but this is my experience on a day-to-day basis, what I have gathered. Importer be educated about filing of the proper documents to avoid dispute and delays, which I have said right through my presentation. Better to follow the templates as prepared by the Indian government for the certificate of origin to avoid dispute and delays in getting the preferential tariff treatment. If three things, the last three things, if you keep in mind, I don't think there is going to be any difficulty or impediment in claiming that right under the said agreement. Dispute relating to the tariff classification decided by the custom officer, then the commissioner of appeals, then the Sisted, the High Court and Supreme Court. Advisable to classify the goods correctly in the documents and give details when claiming exemption or preferential treatment. Basically, it's importer who bears the duty in India. Importer be educated on classification, because some of the importers are very from remote areas. They are not familiar with the classification. So I think it's to like the exporter and really needs to really handhold these people and tell them on the classification aspects and the goods that is being exported. And lastly, I would like to say that because judicial proceeding in India really, because of population and the pending proceedings, it really takes long for settlement in India, and it's hence better to be cautious right from this start in order to avoid any prolonged litigation. These are some of the links where you can get this forms, or you can really, if you have any issue query, you can reach to these links. They can be of quite helpful to you. That's it.